What if I told you that a family could spend thousands of dollars hiring a respected law firm to protect a special needs child, carefully follow the Medicaid and SSI rules exactly as they existed at the time, and still end up accidentally destroying that child's benefits years later because the government changed the rules after the parents had already died? Most people assume that if an attorney followed the rules, the plan should continue working forever. Unfortunately, government benefits planning does not work that way. Medicaid rules change, SSI rules change, administrations change, budget priorities change. The very same government that encourages one strategy today can completely reverse direction years later when financial pressure or political priorities shift. That is why I become very nervous when I hear people celebrating new government benefit legislation as if it permanently solved a problem forever. Right now, there is a tremendous amount of excitement surrounding recent North Carolina changes involving ABLE accounts because many families believe these changes mean ABLE accounts are now fully protected from Medicaid Estate Recovery. While I understand why people are excited, I also believe many families are missing a much larger danger hiding right underneath all of this. One of the biggest mistakes in estate planning is relying too heavily on what the government says is acceptable today instead of relying on long-standing planning principles designed to survive changing laws and changing circumstances decades into the future. Several years ago, an uncle brought his nephew into my office for what he described as a second opinion regarding a special needs trust administration problem. The nephew's parents had died unexpectedly in a car accident years earlier, and before their deaths, they had hired a large law firm to prepare their estate planning documents because they wanted to make absolutely certain that their son would always be financially protected. According to the uncle, much of the planning work had been handled by a younger associate attorney who apparently wanted to demonstrate a detailed understanding of Medicaid and SSI eligibility rules. At the time the documents were drafted, the attorney focused heavily on the fact that a disabled beneficiary could generally own approximately $2,000 in countable assets, one vehicle, and a primary residence without automatically losing certain government benefits. Instead of keeping all the assets inside a properly drafted discretionary special needs trust, the attorney attempted to engineer the inheritance around the exact rules that existed at that specific point in time. The trust directed that the son receive the family house outright, a vehicle outright, and approximately $2,000 outright, while the remaining assets remained inside the trust. On paper, I'm sure the attorney thought this looked sophisticated and efficient. He was likely trying to show the clients how well he understood the government benefit system and how carefully he had customized the inheritance around the rules that existed at that moment. The problem, however, was that life did not freeze in place simply because the documents had been signed. By the time the parents had passed away and the trust administration actually became active, years had gone by. The son already owned a vehicle. He already had money in his own account. More importantly, Medicaid laws and eligibility standards had evolved over time. The uncle explained to me that the attorney at the large law firm was now telling him that the inherited house itself had become a Medicaid problem and that he may need to take out a mortgage against the property on behalf of the nephew and spend the proceeds down in order to restore Medicaid eligibility. The uncle sat in my office visibly frustrated and told me that the entire situation sounded insane because the parents had specifically hired professionals to prevent exactly this type of disaster from happening to their son after they were gone. Unfortunately, I had to explain to him that the original attorney's mistake was not that he failed to understand the rules. In many ways, the attorney understood the rules too well. The problem was that he became so focused on demonstrating knowledge of the current Medicaid regulations that he ignored the far more important long-term planning principle that should have controlled the entire estate plan from the beginning. The assets should have remained inside the properly drafted trust under the sole discretion of the trustee. That principle survives changing laws. The principle survives changing Medicaid regulations. The principle survives changing family circumstances. But once the assets were distributed outright to the beneficiary personally, the flexibility of the trust structure was lost, and years later there was no easy way to repair the damage after the parents had already passed away. That experience has stayed with me for years because it perfectly illustrates why families should be extremely cautious whenever government agencies, legislators, or financial institutions begin encouraging people to heavily rely on today's government rules, remaining favorable indefinitely into the future. Families often hear these programs explained as if the current law is some permanent guarantee carved into stone, when in reality, government benefit systems evolve constantly based on politics, economics, and budget pressures. That brings us directly to the recent North Carolina ABLE account changes. Right now, many people are celebrating because North Carolina appears to be attempting to limit or eliminate Medicaid estate recovery against ABLE accounts after the beneficiary passes on. On the surface, that sounds extremely positive for families dealing with disabilities and special needs planning. Families understandably hear this and assume that the ABLE accounts have now become safe long-term locations to accumulate inheritance money for disabled children and other loved ones receiving any government benefits. What concerns me, however, is that federal Medicaid law still contains language stating that the state shall seek recovery against certain amounts remaining in ABLE accounts after the beneficiary's death. Lawyers can debate how aggressively those laws will be enforced, how the federal and state laws interact, and whether North Carolina's current interpretation will ultimately prevail, but I believe many families are missing the larger issue entirely. The larger issue is that people are once again being encouraged to trust that today's government policy will remain favorable years or even decades into the future when the plan finally matters. That is not a gamble I believe families should make when planning for a disabled child or loved one who may depend on government benefits programs for the rest of his or her life. Governments change, administrations change, legislatures change, economic conditions change, budget shortfalls create political pressure. A strategy that sounds perfectly safe today can become a serious problem years later after political priorities shift or governments begin searching for additional sources of recovery revenue. The lesson from the story involving the special needs son was not merely that one attorney drafted documents poorly. The real lesson was that the planning should focus on durable principles instead of trying to outsmart a constantly evolving system. For that reason, my recommendations regarding ABLE accounts remain largely the same even after these recent North Carolina changes. I believe ABLE accounts can absolutely be useful tools when used properly, but they should generally be viewed as management tools rather than long-term inheritance repositories. In many situations, an ABLE account works best when a disabled beneficiary uses it to temporarily hold funds necessary to remain below those mandatory asset limits while utilizing those funds for their own benefit under the applicable rules. What concerns me is when families begin viewing ABLE accounts as substitutes for properly drafted discretionary trusts or as permanent locations to accumulate substantial inherited wealth. Similarly, I generally do not recommend that parents, grandparents, or other family members start placing substantial inheritance money directly into these ABLE accounts, simply because state agencies or officials encourage it. Once funds become heavily connected to government-controlled systems, those funds remain vulnerable to future changes, future recovery laws, and future interpretations that may look very different from today's political promises. In my opinion, families should be extremely cautious about relying on future government restraint when future governments may face very different financial pressures. Most importantly, I continue to believe that estate plans involving special needs beneficiaries should still be structured around properly drafted trusts that keep inherited assets under the sole discretion of the trustee whenever appropriate. That fundamental planning principle has survived decades of changing Medicaid laws, changing SSI regulations, changing tax laws, and changing political administrations precisely because it preserves flexibility instead of relying on assumptions about what the government may or may not decide to do years later. The families who often suffer the greatest financial damage are not necessarily the ones who ignored the rules entirely. In many cases, they are the families who relied too heavily on the exact wording of rules that later changed after it was too late to fix the plan. If you want to better understand how special needs trusts, Medicaid planning, incapacity planning, and long-term asset protection strategies actually work together, make sure to subscribe to this channel and check out the additional resources linked below, including materials at freemedicaidcourse.com. These are exactly the types of issues families need to understand years before a crisis occurs, because once someone has already become incapacitated or passed away, and once the government changes the rules after the fact, the planning options often become far more limited. And so, as I always tell my clients, please stay safe, plan ahead, and enjoy life, and whatever you do, make it a great day.